So, festival has a rule, no weapons within the venue. So, two options here. You can take it secured in your vehicle, or we can take you over and refund your money to you.
There was a third option not mentioned that day back in the summer of 2019. File a lawsuit, which is exactly what happened. Boy, times have changed since 2021, haven't it? All right, so that's exactly what happened. A lawsuit was filed. That happened when the man whose left shoulder you saw in that POV video, then just a private citizen of Sagal and Second Amendment concealed carry advocate, now State Senator Scott Herndon, well, when he was denied access to the festival at Sandpoint, an 8-day music festival held in Sandpoint's War Memorial Field on the banks of the Pend Oreille River. It's been there since 1983. In a 24-minute video posted to YouTube, Herndon spent 10 minutes making his case to security personnel to be allowed to bring a gun into the festival, even invoking race into the argument.
So is it arbitrary and capricious?
You can discuss that later.
If we were black, would you let us into the festival?
Let me get the police officers, they could deal with it.
Okay, go ahead and get a police officer. That'd be great. Thank you. Maybe they can explain the law.
If we were black, would you let us in? Well, the law would have to be explained not by a police officer, but by a judge, because a month later, the Bonner County Commissioners and the Bonner County Sheriff chose the mysterious and unmentioned door number 3 in this scenario, suing the city of Sandpoint and the music festival for violating a person's right to carry a gun. That lawsuit was thrown out. But then Mr. Herndon and his friend Jeff Avery and the Idaho Second Amendment Alliance took their shot, filing their civil lawsuit against the city and the festival in May of last year. By June of 2021, a district judge ruled in favor of the city, saying the festival organizers, they can set up any rules they wish since they legally take control of that park, something the mayor of Sandpoint told us he saw coming. You guys aren't even involved in this because you leased this property out for this time being, and they can make the rules.
That's right.
I mean, is that as simple as it gets?
That's as simple as it gets. That's right.
That seems like, and I don't want to throw out the word frivolous, but it seems like that would be kind of known. Like that would be one of those things, like if you run out of space, you can kind of tell whomever you can't come in because of X, Y, and Z.
I agree. I think frivolous is the right word, frankly.
Well, frivolous, an adjective having no sound basis. So right about the time Mr. Herndon was deciding to run for the District 1 state Senate seat, he decided it would also be a good idea to appeal that ruling to the state Supreme Court. Even posting about it on Facebook in August of 2021, our case is before the Idaho Supreme Court. I am an absolutist when it comes to the Second Amendment. No infringements. Well, Senator Herndon, where do you stand when it comes to the rights of private parties to set their own standards? No infringements there either, because that's the side the state Supreme Court stood on today, rejecting Herndon et al.'s appeal, saying the lease between the city and the 8-day music festival was valid, and the festival, a private tenant, had the authority to limit who they let in. In its rejection of the appeal, the court affirmed the district court's decision for the city and the festival and awarded them attorney's fees, which we know from the first lawsuit, which was thrown out in 2020, totaled about $71,000 that Bonner County had to pay the city of Sandpoint. So what could that total be for a 3-year case taken all the way to the state Supreme Court, asking for a financially conservative friend? So a private entity can limit the ability to bring a gun into their event, even if it is held on public property. So what might the plaintiffs of this lost lawsuit might have to say about it? Well, the Second Amendment Alliance, Idaho's Second Amendment Alliance, posted this morning. Idaho courts has, for all intents and purposes, gutted Idaho's firearm preemptive law. They gave cities and counties a wide open door to ban guns across the state using a lease loophole. Governor Little should call an emergency special session to fix this problem. I wonder if we're going to see a bill about this next year. Well, according to Senator Scott Herndon, we will. His reaction today, he says today's court's decision provides a mechanism for cities to take away the average law-abiding citizen's most effective tool at protecting innocent lives. I will go to the mat to find a legislative solution for Idaho's gun owners. While property rights are fundamental, gun rights are equally fundamental, he said, and the right of self-defense must be protected on public property. So what about the winners? The festival at Sandpoint said basically, yeah, no kidding. We saw this coming as well. Since the original lawsuits were deemed to not have merit, we were confident the Idaho Supreme Court would have a similar and favorable decision. The safety of our fans, volunteers, staff, and artists is of the utmost importance and continues to be at the forefront of everything we do at the festival at Sandpoint. By the way, that festival kicks off July 27th with such acts as REO Speedwagon, Train, Gary Clark Jr., and Ashton McBride. Don't forget your tickets, but also don't forget to leave your guns in the car.
What is the best thing I've ever done in my life? When I die, I will say, number one, I raised a good family, and I lived a good, I tried to do good. Number two, I passed this policy.
And pass that policy he did. That is Nampa School Board member Marco Valle showing his support for Policy 2050. A man who once provided food for the poor while working for the Idaho Food Bank says the passage of this policy ranks higher than that. Critics have compared this policy to that of Florida's Don't Say Gay bill. The Nampa School Board approved it this week, and it restricts teachers from having conversations about gender identity, sexual orientation with any student in the school. And if a student does bring up one of these topics, well, then they're referred to a counselor. Then the counselor then is going to refer that student back to their parents. Timeless circle there. That's a good time to bring in Andrew Bartline following this policy for us this week. So what does this policy 2050 say exactly?
Well, first, it kind of defines these terms that apply specifically,
Okay.
Brian. So we look at these terms individually. It includes gender identity, gender expression, sexual orientation, and transgender identity. For each of these terms, after they define them, the policy says the district will not educate or discuss any of these topics. And they state it's the responsibility of the parents to have these conversations, which is the crux of this bill and the people who support it. It passed behind a 3-1 vote, though that lone vote that opposed the bill happened to be the only person on the school board who's actually a teacher. Supporters say this policy is about protecting parental rights, however.
There is no place in my world where the school district becomes the parent to that child. They could become the caregiver or the guardian for a certain amount of time, but they do not become the parent if there is a parent for that child.
Now, the point being that these conversations, the district says, should be reserved for parents to manage at home on an individual basis. But the lone board member who opposed, Mandy Simpson, the one who is a teacher, she pointed out not every student has an open line of communication at home with their parents or legal guardians. She sees it in the classroom, and other people out in the community in Nampa, well, they see it too.
The bulk of our age group is about 16, 17. So.
Mandy Oldenkamp works at Clutch,
Director of Operations.
a Nampa-based LGBTQ+ youth advocacy group.
A lot and a little, all in one.
All in 1 year.
And we just wanted to offer a place where there was going to be no judgment, no expectation, just a free space for these kids to be completely comfortable being themselves in their own skin, whatever that looked like on any given day.
Why is something like that needed, I guess?
Nampa is a place where there's a lot of very traditional values and a lot of very tight-knit families, and that doesn't always fit the mold for all of these kids. Some of them are not out in their home life, so their parents aren't fully aware, or maybe are aware and not accepting of who they are. These are kids that feel ostracized by maybe their religious upbringing or the community in which they immediately live, you know, their neighborhoods, their schools, and they just needed a place to come and feel accepted.
The people who support this policy have expressed concern that schools are hiding things from parents about their kids. They're probably going to feel the same way about your organization when they hear what you do.
And that's fair. You know, I think it's important for parents to be very engaged in their children's lives. I'm super involved in my kid's life. My parents were super involved in mine. But that has to be done in a safe and constructive manner. And I would hope that every parent had the tools and ability to do that. And if they don't, that they know that there are resources out there and that conversations can be had in a healthy manner to help make that relationship better.
So here's a copy of the policy right now. Do you talk and work with kids who belong to all of those groups?
Yes. Yes, these definitions represent our entire demographic. Truthfully, the way that this policy is worded, sexual orientation should include heterosexual orientation. So if a teacher is not allowed to talk about sexual orientation, it should be on both sides of the spectrum. It should be heterosexual, homosexual, whatever orientation that might be. But I have a suspicion that that maybe not be the case as it gets implemented.
you don't think sex ed is going to prohibit heterosexual encounters?
I don't think so. So then it does feel like a narrow-minded, discriminatory policy. It feels very much like a portion of the population is just being erased from the schools themselves. And it doesn't make the kids feel secure, it doesn't make the community feel safe. You know, my concern for the kids in this coming school year is that they're really going to feel like they don't have a place and that they don't have a voice within their own school, a place that they spend the majority of their time. So they share a lot about what it feels like to not feel like they're accepted in their own skin, and what it means to really be different in a world that doesn't always recognize different as a good thing.
The policy also aligns with Senate Bill 1100 that passed this last legislative session, and it has been signed into law. That bill prohibits students from using a bathroom outside their biological sex. This policy aligns with that exactly. The district is determining a student's gender based on what they see on their birth certificate, and this policy also outlines compelled speech too, Brian. So hypothetically, a student comes into your classroom and says, I use they, them pronouns. The teacher doesn't have to call them they, them pronouns. If that student had a birth certificate that says they're male, the teacher could decide to use he, him pronouns.
Mandy brings up a good point. How do you teach sex education if you're not allowed to talk about a certain portion of the population? Just pretend they don't exist?
Well, I mean, if you align it and you're not being biased toward one side or the other, like gender identity, sexual orientation, if you can't talk about them at all, I mean, you can't teach those classes.
You can't. It's an impossibility. Thanks, Andrew. Capital punishment in Idaho goes back to territorial days. The first execution came in 1878 when a man named Tom Biago, a member of the Bannock tribe convicted of murder, was hung at the old Idaho Pen. It's a place where 10 men were put to death for their crimes. Today, the Gem State is one of 27 states where capital punishment is still a thing. In fact, last year, because of a difficulty in getting medications necessary for lethal injections, Idaho brought back the firing squad to fulfill such sentences. It's doubtful that approach will be used anytime soon, since only one person has been sentenced to death in Idaho since 2011. It's because the time spent on death row usually lasts decades. Idaho has 8 people on death row right now, 7 men, 1 woman. And on average, those inmates spend 27 years on death row trying to get off it. Thomas Creech, convicted of murder back in 1976 and again in 1982 for killing a fellow inmate. All told, he has spent 47 years on and off Idaho's death row, which seems like a lot of work and a lot of time for a little outcome as far as the state is concerned. So who decides to make a murder case, for example, a death penalty case? Well, that's usually up to the prosecutors, who, should they decide that's the way they want to go, well, the clock starts with the weeks it could take to find a jury.
It would typically start with a jury questionnaire that is fairly lengthy, that identifies a number of these issues, including their attitudes about the death penalty. When we're selecting a jury for a capital case, if somebody indicates that they would be unwilling to impose the death penalty, that they're morally opposed to it and couldn't do it, that person wouldn't be qualified to serve on the jury.
Prosecutors also must know they can prove aggravating factors or circumstances, which are a much higher burden.
And so that's an additional burden of proof.
Those circumstances make the crime more heinous or severe. In Idaho, some of those include whether or not the murder manifested exceptional depravity, if it was exceptionally cruel, or if the defendant exhibited utter disregard for human life or acted with mayhem.
Then they go to a penalty where the sentencing is actually done by a jury. And in Idaho, you have to have a unanimous jury return a death sentence, right? And so it only takes one person to decide to spare the defendant's life.
Okay, so KTVB investigative reporter Alex Duggan spent weeks working on this story about the death penalty here in Idaho and how this process isn't really so easy. So I guess the first question is, you're going to see that story tonight at 10, but what factors play into how long and difficult this road is to, well, I guess, completing a death penalty?
Well, Brian, prosecutors have to prepare for a death case, and so does the defense. The defense has to prepare for a death defense, which takes a significant amount of time. And Wendy Olson said it best in one of the Kober hearings that they're fighting for his life. Yeah. And so it's really a life or death scenario in this situation. And to basically file for a death penalty case, you have to know that those aggravating circumstances are something that you can prove. Right. It has to be more heinous. It has to be more atrocious. It has to be reckless. They have to, have caused mayhem. It has to be so severe that prosecutors know that a jury would be able to decide on that.
So it has to be, they fine-tune this and they say it has to specifically fit this criteria.
Yeah, and then the jury would decide. The jury only has to decide on one of those aggravating circumstances that would be in existence, and then they can move into the next phase, which is the death sentence phase. Okay, so 27 years on average that a person will spend on death row in Idaho. That's a long time. And you're saying because, well, there's a lot of appeals that go into this too, right? Once you get sentenced to death, then there's a whole appeal process that goes along with that. Right, exactly. The appeal process can take years, and that's because we just have a lack of, federal judges. There's just so much time that they have to go back and review from start to finish these cases, and that can just take so much time. Okay, so you mentioned one of the reasons that this takes so long. It's because it has to do with who actually is hearing these appeals.
We just don't have enough federal judges. And our federal judges are already overworked with all of their other stuff.
If someone has exhausted all their appeals, they can appeal the U.S. Supreme Court as a last resort. Anderson has dealt with death penalty cases in Idaho for 26 years. He has so many stacks of paper on each death penalty case, he had to move them to a separate office.
I have banker's boxes, literally banker's boxes, of files that start from the time that someone's indicted or charged with a capital crime all the way through the federal court system that take up anywhere from upwards of 30, 40 boxes. Wow. It's a lot of paper.
So that's a lot we're going to learn tonight. What else are we going to learn tonight?
Mostly just about the appeal process, more details, kind of getting into the nitty-gritty of things, and especially how that kind of plays out with what we're seeing in the Koberger case, in the Moscow killings, and what that looks like and what prosecutors could be doing right now.
Because they're still considering that with him, correct?
It has not been filed, so it's a possibility. Okay. Because that's the penalty for first-degree murder in Idaho is the death penalty or life in prison.
Awesome. All right, thank you very much, Alex. There's always been this question of which costs more, too, sentencing someone to death or life in prison. Back in 2014, Idaho's Office of Performance Evaluations, which is an independent group of analysts who are charged with improving the effectiveness of state government. Well, back then, 9 years ago, they were asked by then-Senators Elliott Work and Cliff Bayer to evaluate Idaho's death penalty system, calling it fragmented and inefficient. They wanted a better understanding of how it works and what it costs ultimately and how it compares to other states. The goal was to hopefully save the state millions of dollars to eliminate unnecessary wasteful spending. But the OPE could not put a dollar amount on it because they found most of Idaho's state and county agencies, the criminal justice stakeholders involved, they didn't do a very good job of tracking how they spent their time in such pursuits. They did conclude, because capital cases take longer to complete than non-capital cases, it does cost more to see a death sentence through to the end. Even just the trial portion. They usually take 7 months longer than non-capital cases. And there has not been another request to look into the death penalty system in Idaho since 2014. You can watch the entire first part of Alex's story on the death penalty for Kohberger tonight on the news at 10. Part 2 coming up tomorrow night.
It's the #1 vegetable grown in Oregon. It's the #1 vegetable consumed in the entire United States.
Aren't you worried about stepping on any toes of, say, I don't know, one of your neighbors?
No.
Of course not. That's Oregon State Senator Bill Hansel, who introduced a resolution to make the potato the state vegetable of the Beaver State, even though it's not even the second or even the third largest potato producer in the country. It's fourth behind us, obviously, and then Washington and finally Wisconsin. Okay, so fast forward 6 months.
Senate Concurrent Resolution 3, designating potato as official vegetable of Oregon.
Give us some grace and let's talk petunias.
Sorry, Rep. Owens. I like the petunion too, but I believe that supporting potatoes and French fries and the farmers who grow them is one thing we can all agree on.
I actually got a request from some onion farmers to oppose this bill. Sorry, potato lovers.
There's going to be some French fries out in the little lobby area from McDonald's. Go potato vegetables.
Senate Current Resolution 3, having received the required votes, is declared adopted.
There you go, just like that. Oh, French fries from McDonald's in the lobby, you say? Probably cut from Idaho potatoes, since the Simplot company remains a major supplier to the Golden Arches. Okay, so Idaho and Oregon now have the same state veg. An underground attempt to bring us closer to greater Idaho? Well, another way Oregon is becoming more like Idaho, and really the rest of the country. Oregonians are one step away from pumping their own gas for the first time since 1951. Oregon Senate just passed the self-service gas bill. Just needs a signature from Governor Tina Kotek and would go into effect immediately should she sign it. But what about the loss of, say, I don't know, gas station attendant jobs? Well, this bill wouldn't get rid of all of them. Gas stations will still have to keep half of their pumps for full service. And get this, It's going to cost you the same price per gallon, full service or self-service in Oregon. And if the bill becomes law, well, that just leaves New Jersey as the last state that won't let drivers pump their own gas. All right, lots of comments today about Policy 2050 in Nampa, like this one from Roger in Boise. LGBT kids, he fears for them in Nampa. Teen suicide is also at a crisis level. Pray that it doesn't rise even more. Yes, Brian, they are trying to erase those kids. They don't even want them to exist, says Sheila. We're talking about not even being able to mention homosexuality in a sex ed class, according to Nampa School Board. If guns aren't allowed at the private gathering, why would you need a gun to protect yourself? We would only need to protect ourselves against those carrying guns, right? Asked Jill in Garden City about Scott Herndon trying to get into a music festival with a gun, both concealed and, well, carrying it out in the open. Why is no one reading the Second Amendment correctly? Regulated is the key word, and individuals are not regulated, says Larry, when it comes to what your rights are. Death penalty, very efficient and a good deterrent. Lawyers who work with it are not. Joe Ford blaming the lawyers. Not sure that's the case. We'll see you back here tomorrow.